And the next case is State of Florida Agency for Persons with Disabilities versus Sally Toal. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
And I'd like to reserve 5 minutes for rebuttal.
You may proceed.
May it please the Court, my name is Miriam Coles of the Henry Buchanan Law Firm. I'm here today on behalf of the Agency for Persons with Disabilities. The only issue before the Court is whether Florida's Public Whistleblower Act waives sovereign immunity for the recovery of uncapped, non-economic pain and suffering damages in the absence of express statutory language enumerating that category of relief. And we would contend that the answer is no. The state of Florida, including APD, is entitled to absolute immunity from liability absent clear waiver of immunity that is unequivocally contained in the language of the statute at issue. Courts do not have the authority to waive sovereign immunity. That authority is with the Florida legislature. Sovereign immunity is the rule, not the exception. And sovereign immunity draws from the doctrine of separation of powers. It considers important issues about protecting the public treasury as well as maintaining the orderly administration of government. The standard of waiver for sovereign immunity is well established in Florida law, and it mirrors the federal standard for the application of a federal waiver of immunity. And it's a three-part standard.
Counsel, you might want to pull that microphone down a little bit.
Thank you, Your Honor. It's a three-part standard. First, a waiver of sovereign immunity must be clear and unequivocal. The Florida Supreme Court held that years ago in the Spangler opinion, and this court has repeated it recently in Caldwell and Hightower. Also, the United States Supreme Court declared in the Cooper case that waivers of sovereign immunity must be unequivocally expressed. Interestingly, Caldwell and Hightower, when they describe the clear and unequivocal standard, they talk about being clear, specific, and unequivocal. Specific meaning clearly defined or identified, meaning that the waiver of sovereign immunity has to be clearly identified and defined. Second, a waiver of sovereign immunity cannot be the product of inference or implication. As the court held in Hightower, waiver of immunity should not be found where it can only be inferred from or implied by the text of the statute. Similarly, Caldwell said, and I'm paraphrasing a little bit, but if you have to infer a waiver of sovereign immunity, then it doesn't exist because it's not clear and unequivocal.
The trial judge relied on Iglesias out of the third DCA. Distinguish that case for us, and certainly it's not binding on our court.
Yes, Your Honor. Iglesias relied on a first DCA footnote in the 2008 opinion of O'Neill versus FAMU, and that case did not address sovereign immunity. It did not even address what relief was recoverable under the Whistleblower Act. It addressed whether or not you're entitled to a jury trial in a whistleblower case. But there was dicta in a footnote that the Iglesias court relied on. Iglesias held that the must include language of subsection 9 of the whistleblower statute implied a floor rather than a ceiling. And the court, I think, hanging its head on liberal construction, ruled that because the language of the statute does not, quote unquote, expressly exclude recovery of pain and suffering damages, then we can imply a right to recover it. The problem with the Iglesias holding is they do not consider sovereign immunity at all, and nowhere in the opinion does the court reconcile how you can square its holding of an inferred right to pain and suffering damages with the well-established principle for waiver of sovereign immunity that it has to be clear, specific, express, and unequivocal. In addition, in Iglesias, the court doesn't address what are the parameters of this implied right. So if it doesn't expressly exclude recovery of punitive damages, can a court award punitive damages against a governmental entity under subsection 9 if the language of the statute is just a floor and not a ceiling? Could a court award treble damages against a governmental entity? There's as much statutory authority for award of punitive damages under the whistleblower statute as there is for pain and suffering damages. And so we would contend that Iglesias is wrongly decided. And in fact, the inference is clearly at odds with this court's opinion in Hightower.
Well, counsel, let me go back to Iglesias. I mean, since it did not construe sovereign immunity at all, we would not be in conflict with that decision if we held differently in this case, correct? And otherwise, we don't have to certify express and direct conflict when it did not touch on sovereign immunity at all.
I think, Your Honor, it certainly did not address sovereign immunity, and the case law says it's not binding. I mean, we presented that it was not binding on the trial court because it did not address that issue. So I think that's a fair understanding of the issues presented. Certainly, we are asking this court to reach a result, the result of which is the opposite of what the Iglesias court reached. In terms of the requirement for an inference, I think this court in Hightower very directly explained what is not permissible. Hightower involved the military statute in Florida, the Florida's Uniform Services Protection Act, and the issue was whether or not it waived sovereign immunity for suits against state agencies for violating USERRA, which is the federal provision. And the plaintiff in that case pointed to pieces of the statute from which you could infer an intent to bring suits against the government. For example, FUSPA directly incorporated USERRA, and USERRA has language allowing suits against the state. FUSPA has language about concurrent jurisdictions for the states. FUSPA had language about civil penalties. And so the court looked at it and said, yeah, you could infer that perhaps the legislature may have intended suits against the state, but there was no clear, express, and unequivocal waiver. And in fact, the court said the argument that canons of statutory construction should be used to read into Florida law a waiver of sovereign immunity that does not project from the plain and unambiguous language of the text underscores the lack of an unequivocal waiver. So in other words, if you have to use principles of ambiguity, if you have to use inference, such as finding that it's not expressly excluded, then there is no clear waiver of sovereign immunity, as this court found in Hightower. And similarly in Caldwell, that involved the Ombudsman Program statute. And the court said, even if we inferred an intent by the legislature to allow suit against the department, that's not enough to have a valid waiver of sovereign immunity when the standard is clear, express, and unequivocal.
Counsel, just to take off on a point that you just made, so immunity has to be clearly and expressly waived, and if there's ambiguity, it goes in favor of the state. But with respect to this act, the Florida Supreme Court in some older cases had said that because it's a remedial statute, ambiguity should be construed in favor of the employee. So is there tension there? If we've got ambiguity, on the one hand, it goes for the state on immunity, but more generally, it goes to the employee because it's a remedial statute.
Your Honor, you're right. There are old cases talking about the whistleblower statute being liberally construed because it's remedial. But liberal construction does not come into play unless there's ambiguity. If you look at the plain language of the whistleblower statute, we would contend it's really not ambiguous. The language says what it says. It says that a prevailing plaintiff, when the court is awarding relief must include the following. And then the statute lists 6 categories of relief, including reinstatement, compensatory damages for lost wages, lost benefits, and lost remuneration. There's attorney fees and costs, injunctive relief, and finally, temporary reinstatement pending the final outcome. So the statute says what it says, and a reasonable reading of the statute is that relief must include these things. In other words, a court doesn't have discretion. Many years ago when the statute first came out, it said relief may include, which implied that a court, even if a plaintiff prevails, a court had discretion and said, well, I'm not going to award attorney fees and costs. By changing the language to relief must include, if you meet the language of the statute, the court no longer has the ability to not give attorney fees and reasonable attorney fees and costs to a prevailing plaintiff. What it doesn't do is then reasonably infer that you could allow any other form of relief that you can dream up. That is not a reasonable or fair reading of the statute in light of the text.
Well, do you think it's significant that we have an allowance specifically of these non-economic damages in the Private Sector Act, but there's an absence of such language in the public sector?
Yes, Your Honor, I do think that's significant. I think, as this court said in Hightower, the legislature is well aware of how to waive sovereign immunity and that the language has to be clear and explicit. And so we have to assume that the legislature knew if it wanted to include pain and suffering damages, it would have done what it did in the private sector, which was to include an expressly enumerated provision for other compensatory damages allowable at law. That's what the private whistleblower statute says. So it has a prong for compensatory wages and remuneration, similar to the public whistleblower statute, but there's an additional provision, a catch-all provision, if you will, that allows for any other compensatory damages allowable at law, which courts have reasonably interpreted to mean pain and suffering damages. There is no similar language in the public whistleblower statute. There is no catch-all provision from whence one could infer some type of entitlement to other compensatory damages. It is silent. Even the amicus brief acknowledges that the whistleblower statute is silent as to whether or not there are other possible forms of relief available. And we contend it's silent because they're not recoverable, that the express, specific, unequivocal waiver allowed under the statute is for the 6 categories of relief. And again, these are robust forms of relief. They are not subject to the sovereign immunity caps of 768-28. That's set forth in the Hare case and in Garrison, that the sovereign immunity caps don't apply. So if you have a plaintiff who recovers $300,000 in lost wages and $250,000 in reasonable attorney fees and costs, all of that is awardable under the public whistleblower statute. But what isn't permissible is for a court to then infer a right to a category of damages that is not contained within the language of the statute. And certainly, we are not contending that there is no waiver at all in the whistleblower statute. It is a statute designed to allow suits against state agencies, but the waiver extends to the express language of the statute. The scope of the waiver is determined based on the language of the statute. I think we would all agree that we could not infer, because of liberal construction, a cause of action that's not contained within the language of the public whistleblower statute. Similarly, we cannot infer remedies that are not contained within the language of the statute. And I think the FAA versus Cooper case, it's a federal Supreme Court case applying the waiver of the federal immunity, and it's really very similar. In that case, the court was looking at a Privacy Act that created a cause of action against executive agencies for mishandling confidential information, and if there's an intentional violation of the Privacy Act, you could get actual damages. And so what the Supreme Court was trying to decide is, does actual damages include pain and suffering damages? And so it looked at the issue of waiver of sovereign immunity, and it recited the same standard that Florida uses, clear, express, and unequivocal. It talked about an unequivocal waiver in the statutory text. And in Cooper, the court said, obviously there's a waiver of an immunity, and the issue is the scope of that waiver. And the court applied the same standard in determining the breadth and the scope of the waiver as it did for determining whether or not the government intended for there to be suits against the state. And so much like the court found in the Cooper case, the Supreme Court found that there was no express waiver because essentially the plaintiffs were asking there to be an inference that actual damages included pain and suffering damages. So too here, when we look at the scope of the relief afforded by the public whistleblower statute, we have to apply that same standard of clear, express, and unequivocal waiver of immunity. And so we would ask this court to reverse the trial court's order and find that the public whistleblower statute does not waive sovereign immunity for the recovery of pain and suffering damages. Thank you.
All right, may it please the court? My name is Ashley Richardson, and I am here on behalf of Ms. Toll. It's interesting, I feel like I'm going to get up here and repeat something that my colleague on the other side said, that we also don't believe there's any ambiguity in the statute. I feel like that happens a lot when I walk into this room. The statute and its language are very, very clear, and in 1992, the legislature saw fit to amend subsection 9 from the permissive use of the word may to the mandatory word must. What they did not do was expand that to say must only. I think this is due to the unique nature of of state employment by these or employees who are employed by the state of Florida. That comes with it a certain amount of additional benefits that may not be available to private sector employees. There's a reason that these statutes are split like that, private sector versus public sector, right? So a public sector employee, they might be, let's say, for example, you're not going to earn the same amount of money that you would in the private sector, right? So you get additional benefits as a public employee. There's retirement, there's health care, there's PTO. If you get terminated, you lose those benefits, and you lose the accrual of those benefits. The legislature knows this. They're the ones that wrote those benefits into existence in the first place, right? So if we have an employee who's terminated and later prevails at a whistleblower claim, the legislature knows that in order to fully make that employee whole, certain things need to occur, such as reinstatement, the reinstatement of benefits, the reinstatement of seniority, all of these things that are going to eventually snowball, say, for example.
Why not, the legislature simply could have mirrored the non-economic damages language that's included in the private sector in the public sector?
Right,
Why
and
not just mirror the language?
I mean, in fairness, that would be convenient for everyone involved here. They didn't. They used the permissive may. So let's say we have a private sector employee who prevails. The court is able to award any of those 5 categories of damages in the Private Sector Act, one of which is compensatory damages. But they are not required to reinstate an employee or reinstate that employee's seniority or benefits to the state that it would have been at the time that they were terminated. That's a critical thing for public employees to be reinstated to that position as if that time gap never happened. So when the legislature amends the statute in 1992, it does away with the permissive and makes it mandatory. There are 6 categories of relief that a judge cannot deny a prevailing employee: reinstatement, seniority, lost wages, which is interesting, the third thing on that list, but attorney's fees, and then they add the temporary reinstatement, again, to stem stem some of the issues that are going to flow from this time gap by putting the employee back in that position during the pendency of this action.
Couldn't the concession be that in the public sector, you certainly have a much more liberal environment for giving somebody their job back, the exact same job, putting them back in? So couldn't that be the concession, so to speak, as to why we've got differing verbiage in those 2 acts?
I think that's a big part of it, that there's the state being such a large and very stable employer. There's a lot of opportunities for, let's say, a government analyst too, to maybe go to a different agency. That's a much more available remedy, but it's also a necessary remedy, because if you're let's say a 30-year veteran of the state, but you get fired, you're going to lose a significant amount of that, what you've accrued over the course of your career if you're not reinstated to that same position, level, seniority, et cetera, as if that gap never happened. That may be an issue for some private sector employees, but it is certainly an issue for public sector employees, so the statutes are drafted differently to accommodate those. The fact that it used to say may and now says must is pretty indicative of the fact that the legislature was aware that they have to give these employees that essentially shift back to the day that they were terminated. We need to start from there and go forward. Otherwise, you're essentially losing all of what you've worked to build as a state employee.
Do you agree that non-economic damages is not among the forms of relief available expressly in the statute?
We absolutely agree that it is not listed in the 6. Our our clear reading of what the statute says is that, hey, if you are the prevailing employee, a court cannot deny you these 6 express forms of relief. but it's not exclusionary. It's drafted in such a way that these forms of relief are required, but they are not, it doesn't exclude other forms of relief.
So for there to be an express and specific waiver of sovereign immunity, wouldn't it need to be written in the statute? Wouldn't it need to be more clear than inferred right to non-economic damages?
We would argue that the list is exclusive, or excuse me, not exclusive, the list is mandatory, and that because it's not excluding any of the other forms of relief, they're just not specifically identified as something that a court has to offer. That list is specific to things that a court must provide an employee who prevails on their suit. And for the purposes of sovereign immunity, I think this is why the Iglesias Court and the O'Neill footnote out of the first don't address sovereign immunity, is because they start with the plain language of the statute, which is the floor, not the ceiling language that Iglesias utilizes, that because it doesn't say must only, or there's not a seventh category that says, and no other forms of damages are available. It's just very specific as to what a court cannot deny an employee.
Wouldn't that mean that the statute should say must include the following but is not limited to?
If we were going to, I mean, it would be convenient if it was that explicit, but it's not, and unfortunately.
I mean, I appreciate your candor that when you repeatedly say, gosh, I wish it did.
I mean,
but it
conveniently,
doesn't. But isn't that really basically an argument for ruling in favor of the appellants?
See-
That sovereign immunity, the waiver of sovereign immunity is a very serious matter. It is a court telling the executive branch and the legislative branch, you're going to pay additional monies. It is something that, as you well know, bumps up into the separation of powers in Article 2, Section 3, a very strict separation under Florida law. We don't have a separation of powers provision like New Jersey, perhaps, which we addressed in an education case. We have, and the Florida Supreme Court talked about in State v. Cotton, a case involving the Reoffender Act. We have a very specific and stringent separation of powers provision. In fact, if you'll take a look at Article 2, Section 3, which I know you have, it talks about no person belonging to one branch shall exercise the powers of another branch. And I'll just submit to you that might include judge. No judge shall exercise the powers of another branch of government. I mean, it's quite stark in its terms. So how do you address this strict separation of powers overarching principle with the idea that, well, the legislature could have been more convenient, they could have said this, but we just want you to infer it from the word must?
Well, I think that the use of just the word must is where that comes from. Had the intention been to exclude all other forms of damages, must only solves that problem. And they elected not to do that and just maintained the list of things that a judge has to put out there for the prevailing employee, but not to the exclusion or detriment of any other form of relief. And it's looking at the sort of plain language of the statute. And my colleague on the other side referenced the Hightower case, which quotes from the Clonus case that says that in order to review the provisions of this statute, we need to look to the provisions of the whole law and its object and policy rather than nitpick these, specific sections. And that's where I think the fact that the legislature saw fit to protect these very specific to state employees, like their forms of recovery, and ensure that they weren't denied those forms of recovery. So a judge can't just say, well, you prevailed, here's your pile of lost wages, off you go. And you have a 20-year veteran of the state going, well, where's my retirement? Like what, how do I solve this? The fact that they saw fit to sort of close that loophole.
So under your argument, if a plaintiff prevails on a claim, in this case, for example, or any case, for pain and suffering, and your opponent concedes there's no statutory cap on any of these damages, right?
Yes, I believe that was what she said.
So if a plaintiff obtains a $50 million pain and suffering judgment against the agency for the mental anguish, and I'm not suggesting that that doesn't occur, for the pain and suffering that they incur, that $50 million judgment against the state of Florida has to be upheld for pain and suffering.
I would argue that the way the statute is currently drafted, that is the situation that we find ourselves
That
looking
has
at.
to be,
Yeah.
logically, right?
Yeah, that would be, that's our position, is that's the natural flow of what the language of the statute says.
Because there's no limit. I mean, and pain and suffering damages by their very nature are difficult. I think it's been repeatedly recognized for juries to evaluate.
I was going to say, as a plaintiff's
It's
attorney,
not-
I would agree with that.
You don't have an economist saying, okay, well, this is your average wage, this is what you would normally earn over a 20-year period, this is how much that wage would increase. Pain and suffering is highly subjective.
Correct.
So,
No, I would agree with everything you
so
said.
whatever a jury decides is the appropriate amount of pain and suffering damages against the sovereign is appropriate.
Given the way the statute is worded and the trust that we vest in juries, I would say that the answer to that question is definitely yes. So I think, again, following what I just mentioned about the CLONUS decision, just referencing how statutes should be evaluated, if we look at the purpose of the act, what it's trying to preserve, the rights of the employee that it's trying to protect should the employee prevail, the availability of compensatory damages has always existed, particularly since the 1992 amendment, where we make it clear that this specific set of categories is for sure to be awarded to a prevailing plaintiff. So our argument would be that sovereign immunity has been waived on this issue the entire time. And that is why the Iglesias court, most likely, obviously I wasn't there, would not have evaluated sovereign immunity because they looked at the whole text of the statute and came to the conclusion that failure to include exclusionary language, or just the decision not to, not necessarily a failure, by the legislature necessarily means that they didn't intend to exclude these alternative categories of damages, but they wanted to ensure that employees of the state who were wrongfully terminated, and it was found that that was the case, were made whole again.
So every remedial statute by the legislature, ranging from damages for environmental pollution caused by agencies, the whole gamut, if the legislature, and the legislature provides a cause of action, and they provide certain remedies, if they don't exclude non-economic damages against the sovereign, then those are available.
I think that's going to depend on the specific wording of that provision. I think
But I mean, that's your argument here, it wasn't excluded specifically, so it has to be included.
In this particular instance, the way the statute is drafted, yes. And I think, again, looking at the companion of the private sector and the fact that all of those damages are permissible, I think that's the reason that we have this difference in the way that the two are drafted and what's included and what's not included, because we're not requiring that a court give a private sector employee specific things. The judge could reinstate the employee or order restitution in some form like that, but they're not required to. Whereas under the public, where we have a totally different set of like long-term vested employee rights, they've decided.
So under the statute, then, as you interpret it, the public employee has greater rights than the private employee.
I wouldn't say that they have greater rights. I think they have different rights.
Well, isn't that greater if you're entitled to reinstatement, all these other specific remedies, and non-economic damages? Doesn't that mean the state employee's in a better position than the private plaintiff?
I think that that could be looked at from a number of different perspectives, one of which
How
being-
is it not more advantageous for the public employee if they have all 6 remedies and non-economic damages?
Well, the other remedies are available in whatever circumstance the judge sees fit in a private sector case. I think that the sort of agreement made between a long-term loyal state employee and the state is like, hey, your pay may not be as significant as it would be if you were out there in the private sector in that market, but we're going to offer you for your years of service this retirement benefits, really good PTO, access to affordable health care coverage. Like you're getting saying, I worked for the state briefly. Those were the reasons I went to work for the state, were to access those benefits as a new parent. So I feel like, you have, I wouldn't say that they have more rights, but I think that because of the nature of public employment, the legislature essentially knows what it's offering those who work for it, and they know that in order to secure those benefits, essentially long-term loyalty to the state is necessary, and that if you have that break in service, you lose everything that you've worked for. And like I said, that may be a situation in a private sector company, which is why those damages are available. And let's say the facts were to bear out that in order to get your pension from your private employer, you needed 30 consecutive years of service. A judge could certainly, under those circumstances, award reinstatement, or eliminate the gap, that sort of thing. But we know for state employees that those things are required in order to secure your end of career benefits. And that's why the legislature saw fit to make sure that those benefits were available, or that that restitution was available in the event that an employee prevails. The list is mandatory but not exclusive, is really the balance of our argument. We see it as a very straightforward, sort of simple argument, the language of the statute is quite clear. Now, to the extent this court were to determine that that's not the case, that is where liberal construction comes into play. We have these statutes, I believe it's the Irvin case was one of the first ones, Edenfield as well, to say that where there is ambiguity in the statute, that ambiguity needs to be resolved in favor of the employee who is, attempting to remediate their loss of rights, essentially. So that would fall hand in hand with, if we have some confusion over this use of must versus must only, which is not in the statute, that should be resolved in favor of the employee.
So even if we were to agree with the proposition that the must is a floor and not a ceiling, that still doesn't answer the question or the requirement that there be an express and specific waiver of sovereign immunity. So there could be other forms of relief that perhaps could be included under the floor argument. But when it comes to an additional component of damages against the state, the Supreme Court has said there has to be a clear and unequivocal and express waiver. Here, there's a silence. There's none of that.
And our argument, and this is mirrored, or I guess expanded upon in the amicus brief, is that because they've waived sovereign immunity for the ability to bring a suit against the state in the first place for whistleblower retaliation, and they've enumerated the specific forms of mandatory damages but haven't excluded any other damages, that waiver is express and unequivocal and covers sort of the gamut of damages that one could expect to see in an employment-related case, which really I think the only thing that we're left with is this compensatory damage. Everything else is sort of specifically included in the mandatory language. So while I agree it's not specifically stated in there, our position, supported by the amicus brief, is that because they waived sovereign immunity in the first place for the entire statutory scheme and didn't specifically exclude this form of compensatory damages, that it's been waived the entire time, essentially.
So if there's no limit on the damages for a public employee, and back to my hypothetical and the $50 million judgment, so that plaintiff is entitled to execute that judgment against the state without a claims bill in the legislature, right?
I honestly, that one goes a little bit far afield for me.
Well, I mean, there's no cap, there's no requirement of a legislative action.
Yeah, I think that's probably accurate.
Because other injured parties who sued the state, who face the cap, do have to obtain specific legislative authorization.
Yeah, and I think that on just as a general principle, I think a lot of times those caps come into play after a judgment is sort of entered, that someone seems, a large judgment comes in and then we go through and maybe this wasn't the way we needed the statute to be written, and that there's a real possibility that could come into play at a later time, as I feel like it has done sort of time and again over the last several decades. But as currently written, the compensatory damages would not be subject to any sort of cap. So once again, our position is that the footnote in O'Neill, followed by the third district in Iglesias, got it right, that the must is mandatory as to the list directly below it, but it's not exclusionary. Sovereign immunity isn't at issue because it was already waived for the whole statute, and we would just ask that you affirm the decision of the trial court.
Before you sit down, I'll ask you about O'Neill. I think that your firm was involved
Yep.
in that case I saw, but, I don't see in any way, I think it's a far stretch to grab that quote out of O'Neill and then equate it to our adherence or agreement with Iglesias. O'Neill was a jury trial right.
Correct. No,
Case,
and
period. So, do you concede that this is a novel issue for this court?
It is,
That we have
absolutely.
not- We have not had any kind of statement or position on this specific issue.
no, absolutely, and I apologize if I spoke too broadly and said, because no, absolutely, O'Neill was, that is dicta in a footnote that was then carried into sort of existence in the third DCA by the Iglesias court. I was merely referencing it as just language, but definitely, it's certainly dicta. All right, thank you.
Thank you, counsel.
Thank you. To answer a question that was posed to opposing counsel, you're correct. Injured persons who sue under the whistleblower statute do not have to submit a claims bill. That statutory scheme is not subject to the cap. Persons who are injured or even wrongful death claims brought in tort against state agencies are capped at $300,000, and they have to seek a claims bill to get additional relief. The legislature expressly, specifically, and unequivocally saw fit to waive sovereign immunity for whistleblower retaliation claims for 6 robust forms of relief. It probably is true that reinstatement is important for public sector employees. That's why the legislature waives sovereign immunity and requires relief of both temporary and permanent reinstatement in the express language of subsection 9. The legislature saw fit to expressly, specifically, and unequivocally provide for attorney fees and costs, as well as for compensatory damages for lost remuneration. But what the legislature did not do is expressly, specifically, and clearly waive sovereign immunity for recovery of pain and suffering damages. We know that the legislature understands how to waive sovereign immunity. It understands that a waiver of immunity has to be clear and explicit. With that understanding, it listed out 6 enumerated categories of relief that must be afforded to a whistleblower plaintiff when they prevail. The appellee's interpretation that must include that these 6 forms, these robust forms of uncapped relief, are just the floor, and a trial court can essentially fashion any relief it wants to, is not a reasonable interpretation of this statute, of the plain language of the statute. And while remedial statutes are entitled to liberal construction in order to the extent necessary to effectuate the legislative purpose, liberal construction cannot be used to defeat a fair reading of the statute grounded in its text and structure. And so, knowing that the legislature knows what is required to waive sovereign immunity, we have to read that language in the context of the statute as a whole and what the legislature knows it has to do to waive sovereign immunity. And this does not waive sovereign immunity for pain and suffering damages. And we know that pain and suffering damage awards can get high. We attached as part of the record a verdict out of, I believe, the Miami area, the Roseman verdict, where a trial court, or a verdict where the jury awarded $3 million in pain and suffering damages. And the appellee asked us to believe that the legislature knew and intended this result. But where in the text of the whistleblower statute is that discernible? Is the legislature's intent for pain and suffering damage, uncapped pain and suffering damages, to be awardable? It's not there. Just like there's no express intent in the statute for there to be awards of punitive damages or treble damages. But why, based on the logic of Iglesias, would those not also be recoverable against state agencies, since they are not expressly excluded? And so we would submit that the must include language can only reasonably interpreted to mean it is mandatory, that this relief must be afforded when appropriate to prevailing plaintiffs. Finally, the Clonis case, that's actually very helpful to us because it demonstrates what the legislature has to do to effectuate a valid waiver of immunity. Clonis is a first DCA case analyzing the Florida Civil Rights Act and whether or not the Florida Civil Rights Act waives sovereign immunity for suits against the state. And the first DCA looked at it and said, well, persons is defined to include state agencies or subdivisions, so clearly there was an intent to include persons or employers. Employers includes a person, and a person includes a state agency. So it expressly is contained in the language of the statute. In the damages section, it talks expressly about state agencies are not subject to punitive damages. It talks about state agencies will be liable up to the cap. And it expressly describes the type of damages, including pain and suffering damages, that are awardable under the Florida Civil Rights Act. That's how you would expect the wording of the statute to be, where it expressly identifies the damages that are awardable and expressly identifies a clear, express, unequivocal intent to waive immunity. And so we would ask this court to reverse the trial court's order and find that pain and suffering damages are not recoverable under the public whistleblower statute.